Thank you, Anquan, for the kind introduction of myself, and I'm really happy to have this opportunity to share my experience and ideas to my fellow IP experts such as yourselves. And I also appreciate your efforts to fight against the sleepiness after having quite a huge and delicious lunch we had together. So during my presentation, if you raise your both hands, I will just continue my presentation, just thinking that you might need some stretch to fight the sleepiness. Otherwise, if you just raise your one hand, I'll be happy to answer any question you might want to ask. All right, let's just start with the my introduction a little bit. Of course, I just grow some hair from them. Yang Peng introduced me like 10 years ago. I started my own practice, and before that, I used to focusing on the electrical engineering parts and SCP patents and everything. But 10 years ago, when I started my firm with my colleague Kono, who is also here today, my co-founder, we started to concentrate on the software and the artificial intelligence technology, which is my main topic for the day. So this is the brief flag in a nutshell of our office. So as a result, now we recognize it by the artificial intelligence that the best IP experts in South Korea. As you can see from the this one, the BARD is the large language-based chatbot model provided by the Google, and Bing is a ChatGPT-based chatbot model also provided by Microsoft. So we examined several times with the question, and every time our names pops up, so we are very proud of it. So yeah. So let me just begin with my presentation topics. Yeah, so today I will cover mainly with what is written in the exemption guideline for the specific technical areas, which is for the artificial intelligence, and also along with our experience for handling those AI inventions. As you can see from the hierarchy, the major governing law for the artificial intelligence technology in Korea is of course the patent law. But underneath the patent law, there is an exemption guideline, and even underneath the exemption guideline, there is an exemption guideline for specific technical areas for the modern technologies, such as artificial intelligence, intelligent robots, and autonomous driving, which is somewhat related to my slides today. So first, I will talk about the patent eligibility. Similar to other jurisdictions, Korean IP Office also demands AI invention should be tied to the physical hardware structure to implement. But oftentimes, in reality, in practice, it is only a matter of formality. So it could be just simply resolved by just putting additional technical features in the preambles, because which I will be discussing further later. It is Korean IP offices are more likely to deal with this problem as the written description requirement problem. As you can see from my slide, AI invention is not a single type of invention. Throughout the production of the AI services, there are many technical aspects to be protected. For example, since the AI technology is very data demanding and data driven technology, there should be some process for making raw data to be digested by the AI model. So these process, we call it data pre-processing process. So some AI-related invention has uniqueness in that procedure. Or some AI invention has some uniqueness in the training session by adopting new loss functions or adopting new data flow during the training sessions. So in that case, AI invention have inventiveness in that area. Or some other AI module have some design their AI module itself by putting additional layers into the neural networks, or having entirely new elements into the AI module, so that AI module can perform excessive efficient functions than prior art. So in that case, AI-related invention has something special in AI module itself. Also, AI invention has uniqueness on how to utilize the output of the neural networks. In that case, we call it AI application inventions. So it is also considered one of the types of AI invention in exemption guideline. So I'll move on to the written description requirements, which I mentioned earlier, which is quite crucial in South Korean AI examination procedure. So why disclosure matters in AI invention? Because as you know, without sufficient description regarding the structure of the AI model, AI can be just a black box. And in open ends up with abstract idea without knowing what's going on inside the AI model. So in that case, it is difficult for a third party to implement the patent idea. So that's why disclosure matters in AI invention so much. So exemption guidelines states that the disclosure must contain information such as data processing method and training data and learning models and loss functions. Although it is described in the exemption guideline, but it does not mean that every single aspects of technical aspects which is written here should be disclosed at the same time in one patent specification. Patent applicant can choose those traits in accordance with which technical area that AI invention has inventiveness for. These are examples of the insufficient description of AI invention. The first one is artificial neural networks undisclosed. This is so-called like black box situation, so that Korean IP office will construe it as just a black box and abstract idea. Or correlation between the input and output data unexplained. In that case, it often occurred that the many AI-related invention is invented when engineer wants to adopt existing AI model to solve his own problem by adopting new correlation between the training data and label data, so that trained AI model can implement the intended function, which was new and inventive compared to the prior art. In that case, correlation between the input and output data should be explained in detail. And the third, if the application merely presents flowchart or block diagram without description, it is also considered as the black box situation. So it could be ends up with decided by the Korean IP office as the abstract idea. And application of AI technology, as you can recall from my previous slide, the fourth example was this case. So the invention has inventiveness not in the structure of the AI model itself, but how to utilize the output of the AI model. So for example, I will just explain this by the example. Since before I arrived at the Qingdao, I was in Shanghai and Guangzhou and Beijing. So I experienced a lot of differences in weather. So I just came up with this example. So let's say that someone has some idea to predict the grain productivity. Such as predict future productivity for rice or wheat and those sort of grains in order to utilize for his economical investments or anything. Then in that case, let's say that he needs AI model to predict the future weather. So he needs AI weather forecast model. But the accuracy of the AI forecast model is not that important because he has special tool or function or rule to predict productivity of the grain based on the future weather forecast. Maybe he acquire all the information regarding weather forecast and he added some other features that he get from somewhere else, and he just made some formula. And then he had some quite working well in the formula to predict the grain productivity. In that case, AI model itself is not that important to prove the inventiveness of his idea. It is more important to how to explain the post-process procedure to utilize output of the AI invention. So in that case, exemption guidelines states that it is only sufficient for applicant to disclose the ordinary process of machine learning, because the structure of the machine learning itself is not the matter for proving its inventive step. For the reinforcement learning, the exemption guideline is quite clear. It's saying that the applicant has to disclose the correlation between the agents, environment, and state, action, and reward. which is a crucial part for consists of the Markov environment. And data preprocessing for training, if the patent application has inventiveness in this area, examination guidelines say that at least the application has to disclose specific process for preprocessing or correlation between the measured data and training data. If you come back with the example that I just presented to you earlier, so in that case, AI, the weather forecast model, has some inventiveness how to train, and then how to train them, or like how to pre-process the data with to fed up to the AI model. In that case, let's say that he or she just came up with the idea how to just pre-process the measured data, which means that all the data, temperatures, and the direction of the winds collected from each weather stations, and he knows how to efficiently pre-process those data so that AI model efficiently training the output, the training data, so that perform like the intended functions. In that case, the applicant should explain the correlation between the measured data and training data in the patent specification. And there is some interesting case study done by our firm here. So this was the registered case by our firm for our clients. So our client was the AI using drug development company. They are using also all the information from the immune system. So in that claim that we file, in independent claim saying that there are a lot of data set which needed to be analyzed, such as major histocompatibility complex and peptide data and amino acid of the sequence, which would be very familiar to the bioattorneys in here. But in independent claim, we did not disclose anything about how to the correlation between those data or how to specifically analyze those data in detail. So we received office action from the Korean IP office saying that the patent claim describes the prediction model, but it does not disclose the prediction model, the composition of the input data, output data, and training data. But we argue that all the claims of this invention define the input data, output data without any description in the claim, but there's a sufficient description in our detailed description for the patent specification. So we argue that the ordinary person skilled in the art will very easily understand what's going on in the patent claim without detailed description in the claim, but from the detailed description, it is quite obvious for ordinary skilled in the art to understand the problem. So it was accepted. Our argument has been accepted, and it was registered on the 2020 July. So you can understand that from this example, you don't need to put everything in the claim, but it is sufficient to remaining onto the detailed description. And second, I will talk about the allowable claim categories for AI invention. As you can see from the types of allowable claims, there's method claim, apparatus claims for sure, and in fourth and fifth, the computer readable storage medium claim. And third looks like the computer program claim, but it actually functions as the same with fourth and fifth because it requires that the computer program should be described as stored in a medium. So at the moment, third and fourth and fifth are actually functioning the same way. As you can see from the three types of unallowable claim set defined by the examination guideline, there's a computer program product claim, and computer program signal claim, and artificial neural claim. So as you can see, it's quite clear that the Korean IP office does not accept the sole software claim without any tying to the physical hardware. But there's an interesting case law which is done by our firm. We managed to register a structure of the neural network model claim last year. So this application is about the speech recognition model using the transformer, which is also used in the ChatGPT and other linguistic models. But of course, again, at the first time we received the office section from the examiner last year. So saying that, yeah, structure of the neural model is not an allowable type of claim categories by the law. But how we argued is that the Patent Act stipulates that the subject matter to be protected and the scope of claim can be expressed as a structure. So it is by law. And also we argue that the Patent Act in Article 2 is about the defining patent eligible matter. But we just argue that this is just a provision. This is not a provision to restrict the categories of the inventions. So we applicant has a free to challenge alternative types of claim scope as long as it is within the patent law scope of the patent law. And also we argue that even though the category of the neural network model structure is described, a person of ordinary skill in the art can clearly understand the scope of the invention without explaining further detail in preamble. So it is finally registered by the CAIPO in last December, which is quite new. But still, it is a bit dangerous to construe that from this case, CAIPO started to accept sole software claim by itself without any ties up with the hardware structure. We just put it into the gray area. We just understood our claim in a way our client prefer, but the CAIPO is trying to understand the way they prefer. So it is not a definitive example of CAIPO starting to accept the sole software claim. For the last, I will talk about the inventive step. So training the machine learning process. So if the application, patent application, have specialties and uniqueness in training in a machine learning structure, the examination guidelines said that either patent applicant has to prove a unique information processing related to the training data should be disclosed or proved, or applicant has to prove a better effect than the predicted effect to the examiner. So if you recall to the previous AI weather forecast example, let's say there's someone just to redesign the training process by adopting, if you just consider typical AI using weather forecast model, typical training data will be just temperature, humidity, and also direction of wind for each geographical points. But someone just came up with the idea that might be useful for rural area, but in the city you have to consider distribution of the shape of the buildings inside, because that will also affect hugely in the weather inside the city. So if someone had that idea and just making training data set, taking consideration into the distribution of the building, in that case, applicant can prove the unique information, which is the distribution of the building in the city, that process related to the training data. And if that training, through that training data, if AI model has better effect than previous one, at least for the weather forecast inside the city, then he can argue that we have a better effect than the predicted effect, or the previous effect in the prior art. So our patent application has to be acknowledged the inventive step. So that is one of the example we can think of. And some AI invention has some uniqueness in the learning module. So if there is some a new model structure of AI applicants adopt a new data flow in their training sessions, or designing new loss functions and etc. In that case, applicant has to prove that there is an enhancement in the speed of the generated learning model or the accuracy of the prediction based on the generated learning model. And this slide, I explained it the domain transfer, but according to the Shin slide and previously, it will be the same algorithm but different scenarios. We are talking about the same scenario. So the examination guidelines say that the invention is inventive if it has solved long-standing unsolved problem or overcome technical difficulty, or achieved a better effect than the expected effect due to the change of the industry. In that case, even the two invention or two algorithms shares same algorithm but different the scenario is applied. Even with that, if the applicant can prove this sort of effect, then it is likely to granted a patent. But there is a negative examples also exist in the exemption guideline, saying that learning logic has been applied to other technical fields if you have a similar input data. For example, like two algorithms using the same input data, such as like images or text or speech, and then it is considered that it is easy to combine. So there has to be something more to overcome the office action. And there's some case study for the from our experience again. So from our experience, that the it's very like easier for us to like have something about the structure of the AI models described in the patent claim. It is more likely to get accepted by the examiner, or if we put like more description regarding the training process, such as like design loss functions or like data flow in the training sessions. And those claims will be it'll be very much easier for us to get registration from the favorable decision from the Korean IP office. So according to the our experience, we strongly advise our client that at least we have like certain type of independent claims with those sort of like technical features that will enhance the possibility to be granted in Korean IP office. Then we secure the one registration, and afterwards we file the divisional application, which also covered by the topic 1 slide in Korea. So we just keep filing divisional application to pursue the broader scope of the protection in the future. That will be one of the viable strategies in Korea you can think of, because in Korea, there is much more flexibility in division application. So you can, except for adopting new matter, everything is possible in filing division application in South Korea. Yeah, this is the last slide that I prepared. Thank you for your attention, and I'll be happy to ask any questions if you have any. Thank you.